In a packed Supreme Court, tension crackles as Attorney General Pam Bondi faces Justice Amy Coney Barrett. Barrett's sharp laugh cuts through Bondi's argument, but Bondi's piercing response stuns the court, leaving Barrett shaken. The courtroom was a crucible of anticipation, the air thick with the weight of a case that had gripped the nation. Meridian Industries versus the Department of Labor. At its core, the case challenged a federal regulation mandating stringent workplace safety standards, which Meridian, a manufacturing giant, argued infringed on its constitutional rights. The stakes were colossal, with implications for labor law, corporate power, and the balance of federal authority. On the bench sat the 9 justices, their black robes a stark contrast to the gleaming marble pillars behind them. Among them, Justice Amy Coney Barrett, known for her incisive intellect and unwavering commitment to textualism, leaned forward, her eyes fixed on the podium where Pam Bondi, the United States Attorney General, stood ready to argue the government's case. Bondi, a seasoned litigator with a reputation for tenacity, had spent months preparing for this moment. Her team had pored over every relevant statute, precedent, and constitutional clause, anticipating the justices' questions with meticulous care. She knew Barrett would be a formidable adversary. The justices' writings on originalism and her skepticism of expansive federal power were well documented. As Bondi began her argument, outlining the Department of Labor's authority under the Commerce Clause, the room hung on her every word. Her voice was steady, her delivery polished, each sentence a carefully constructed brick in the government's legal edifice. But then Barrett interrupted. "General Bondi," she said, her tone laced with a faint but unmistakable edge of amusement, "you're asking us to uphold a regulation that stretches the Commerce Clause beyond its breaking point. Where precisely is the constitutional precedent for this? I'm curious to hear a citation that isn't a creative reinterpretation of Wickard v. Filburn." A ripple of laughter spread through the courtroom, light but sharp, like the crack of a whip. The other justices exchanged glances, some suppressing smiles, while the audience, lawyers, clerks, and reporters, shifted in their seats, sensing blood in the water. Barrett leaned back, her expression one of confident dismissal, as if Bondi's argument were a house of cards already collapsing. Bondi paused, her face betraying no hint of rattled nerves. She adjusted her notes, her movements deliberate, and looked directly at Barrett. The room fell silent, the earlier laughter replaced by a taut stillness. "Justice Barrett," Bondi began, her voice calm but carrying an undercurrent of steel, "I'm happy to address your question with the precision it deserves." She launched into a detailed recitation of case law, starting with Gibbons versus Ogden and moving deftly to Heart of Atlanta Motel versus United States, weaving a tapestry of precedent that grounded the regulation in the Commerce Clause's historical scope. Her words were not just a defense but a challenge, each citation a dart aimed at the heart of Barrett's skepticism. Then, in a move that sent a jolt through the courtroom, Bondi pivoted. "If I may, Justice Barrett, your own scholarship provides clarity here. In your 2018 article in the Yale Law Journal, you wrote that textualism does not preclude a robust understanding of congressional authority when the text and history align. The Department of Labor's regulation is precisely such a case." The audacity of quoting Barrett's own words back to her was breathtaking. A collective gasp seemed to suck the air from the room. Barrett's face, usually a mask of composure, flickered with something, surprise perhaps, or the first stirrings, of unease. The other justices sat up straighter, their eyes darting between Bondi and Barrett, sensing a shift in the courtroom's power dynamic. Bondi pressed her advantage, her voice rising with conviction. "The Constitution's text, as you've argued, Justice, demands fidelity to its original meaning. The Commerce Clause was designed to empower Congress to regulate activities with substantial effects on interstate commerce. Meridian's operations, spanning 40 states, undeniably meet that threshold." She paused, letting the weight of her words settle, her gaze locked on Barrett. The justice's pen, which had been scribbling notes, stilled. For a moment the two women seemed to exist in a vacuum, the rest of the court fading into the background. The spectators were riveted, their notebooks forgotten as they leaned forward, hanging on Bondi's next move. Reporters scribbled furiously, already crafting headlines about the Attorney General's bold gambit. The tension was palpable, a live wire running through the room. Had Bondi overplayed her hand, risking alienation of a key justice? Or had she just rewritten the narrative of this case, forcing Barrett to confront her own principles? Barrett's expression was unreadable now, her lips pressed into a thin line. But her eyes betrayed a flicker of doubt, a crack in her judicial armor. As Bondi concluded her response, citing one final precedent, NLRB v. Jones and Laughlin Steel, Corp., she stepped back from the podium, her posture radiating confidence. The Chief Justice called for a brief pause, but the room buzzed with whispers. Barrett leaned back, her fingers steepled, staring at the ceiling as if recalibrating her approach. The exchange had been more than a legal sparring match. It was a public test of intellect and resolve, and Bondi had drawn first blood. But the argument was far from over, and Barrett was not one to retreat lightly. What would the justice do next, and how would Bondi counter? The courtroom held its breath, waiting for the next salvo in this high-stakes duel. The Supreme Court chamber pulsed with tension, as Pam Bondi's bold response to Justice Amy Coney Barrett hung in the air. Barrett, her composure tested, now faced a choice: counterattack or yield. The next move would define the case. The brief pause called by the Chief Justice did little to quell the electric atmosphere. Spectators whispered, their eyes darting between Bondi, poised at the podium, and Barrett, whose steepled fingers betrayed a mind racing to regain control. The Attorney General had not only parried Barrett's dismissive jab, but had turned it into a weapon, wielding the justice's own words against her. The audacity of it lingered, a challenge that demanded a response. Barrett's gaze, fixed on the ceiling moments ago, now lowered, locking onto Bondi with an intensity that made the room feel smaller. The other justices, sensing the stakes, sat in rapt attention, their usual stoic masks slipping into expressions of curiosity and, in some cases, unease. As the Chief Justice signaled the resumption of arguments, Barrett leaned forward, her voice measured but carrying a sharpened edge. "General Bondi, your citation of my scholarship is noted, but let's not confuse textualism with a blank check for federal overreach. The Commerce Clause has limits, and Meridian argues this regulation obliterates them. How do you reconcile that with, say, United States versus Lopez, where this court explicitly rejected an expansive reading?" Her question was a surgical strike, invoking a landmark case that curtailed congressional power. The room stirred, sensing Barrett's intent to reclaim the narrative. Her tone, though controlled, carried a trace of the earlier mockery, daring Bondi to falter. Bondi, unfazed, stepped back to the podium, her eyes meeting Barrett's without hesitation. "Justice Barrett, Lopez is precisely why this regulation stands. That case struck down a law with no clear nexus to interstate commerce. Here Meridian's operations, factories, supply chains, and labor practices directly impact markets across state lines. The Department of Labor's data shows a 20% increase in workplace injuries without these standards, costing interstate insurers billions." Her response was a masterclass in precision, blending legal reasoning with hard evidence. She paused, letting the numbers sink in, then added, "If I may, Justice, your concurrence in Sailor Law versus CFPB emphasized that agencies must act within their delegated authority. The Department of Labor has done exactly that, as Congress intended." The courtroom inhaled sharply. Bondi's invocation of another Barrett opinion was no accident. It was a calculated escalation, a reminder that she had studied the justice's judicial philosophy as closely as any clerk. Barrett's jaw tightened, A fleeting sign of strain, but she pressed on. "You're sidestepping, General. The issue isn't the data. It's the constitutional boundary. If we accept your view, what stops Congress from regulating every workplace decision, from coffee breaks to dress codes?" The question was a trap, designed to paint Bondi's argument as a slippery slope to federal tyranny. A murmur rippled. Through the audience, reporters jotting down the exchange, sensing a viral moment. Bondi's response was immediate, her voice rising with conviction. "Justice. The line is drawn where the Constitution draws it. Substantial effects on interstate commerce. This isn't about coffee breaks. It's about preventing systemic harm that ripples through the national economy. Meridian's own filings admit their safety lapses led to supply chain disruptions in 30 states. She leaned forward, her hands gripping the podium. "With respect, Justice, your own writings on originalism argue that the framers intended flexibility in economic regulation to meet modern complexities. This regulation fits that mold." The room was a pressure cooker now, every word a spark, threatening to ignite. Barrett's eyes narrowed, but Bondi's relentless command of the law and her audacious use of Barrett's own scholarship had shifted the dynamic. The other justices began to interject, probing Bondi with their own questions, but her focus remained on Barrett, as if the case hinged on this singular duel. Justice Kavanaugh asked about administrative deference, and Bondi pivoted seamlessly, citing Chevron while subtly reinforcing her Commerce Clause argument. Yet Barrett wasn't done. "General, you're asking us to trust Congress's intent over clear textual limits. That's a dangerous precedent," she said, her voice now colder, a warning. Bondi didn't blink. "The danger, Justice, lies in ignoring the text's historical context. The framers wrote for a nation that would grow, not stagnate. This court's role, as you've written, is to apply that text faithfully, not to rewrite it for corporate convenience." The boldness of her words stunned the room. A few spectators gasped, and even the Chief Justice raised an eyebrow. Barrett's pen tapped once, twice, then stopped. A small but telling sign of her rattled state. The exchange had become a public spectacle, each woman testing the other's resolve in a battle of intellect and will. As Bondi fielded a final question from Justice Gorsuch, the courtroom buzzed with the weight of what had transpired. Barrett leaned back, her expression inscrutable but her silence deafening. Had Bondi's relentless pressure cracked the justice's confidence, or was Barrett merely regrouping for a counterstrike? The audience, from clerks to seasoned litigators, sensed the case teetering on a knife's edge. Bondi's preparation had turned the oral argument into a high-stakes chess match, but Barrett's next move could shift the board entirely. The session adjourned for a recess, leaving the room abuzz with speculation. Could Bondi sustain her momentum, or would Barrett find a way to turn the tables? The Supreme Court recess ended, but the air crackled with unresolved tension. Pam Bondi's relentless assault had rattled Justice Amy Coney Barrett, whose silence masked a brewing storm. The next exchange would test both women's limits. The courtroom doors swung open, and the crowd surged back to their seats, their murmurs a low hum of anticipation. The recess had done nothing to dull the intensity of the Meridian Industries versus Department of Labor showdown. Pam Bondi, standing tall at the podium, adjusted her notes with the calm of a general before battle. Across from her, Justice Amy Coney Barrett sat erect, her earlier silence replaced by a steely focus that sent a chill through the room. The other justices, sensing the unspoken duel, exchanged subtle glances, while the Chief Justice's gavel brought the session to order with a sharp crack. Barrett wasted no time. "General Bondi," she began, her voice low but laced with a controlled ferocity, "you've painted a vivid picture of economic ripple effects, but you've yet to address the 10th Amendment. Meridian argues this regulation encroaches on state police powers. How do you justify federal intrusion into workplace safety, traditionally a state domain?" The question was a gauntlet, invoking federalism to challenge Bondi's Commerce Clause defense. Barrett's eyes bored into Bondi, daring her to slip. The audience leaned forward, sensing the justice's intent to reclaim her footing with a question that could unravel Bondi's argument. Bondi met Barrett's gaze unflinchingly. "Justice Barrett, the 10th Amendment reserves powers to the states, but not when federal authority is clearly delegated. The Commerce Clause, as this court affirmed in Garcia versus San Antonio, allows Congress to regulate economic activities that burden interstate markets. Workplace safety in a multinational corporation like Meridian isn't a local issue. It's a national one." Her voice was steady, each word a brick in a fortress of logic. She cited data. Meridian's safety violations led to $300 million in cross-state medical claims last year alone. States can't address that scale of impact alone. Barrett's lips twitched, a flicker of irritation or perhaps respect. She pressed harder. "You're dodging the principle, General. If we accept your view, what's to stop Congress from federalizing every state regulatory scheme? Your argument risks erasing federalism's core." The question was a trap, designed to force Bondi into defending an overbroad principle. The room tensed, reporters scribbling furiously, sensing Barrett's counterattack gaining traction. Even Justice Alito nodded slightly, signaling his interest in Bondi's response. Bondi didn't hesitate. "Justice, federalism thrives on balance, not paralysis. This court's precedent in New York versus United States draws a clear line. Congress can't commandeer state legislatures, but it can regulate economic activity with national impact. This regulation does the latter, targeting Meridian's interstate operations, not state sovereignty." Then, in a daring move, she pivoted to Barrett's own judicial record. "In your dissent in NFIB versus Sebelius, Justice, you argued that federal power must respect constitutional boundaries, but not cripple Congress's ability to address modern economic realities. That's exactly what this regulation achieves." The courtroom buzzed, the audacity of Bondi's citation electrifying the air. Barrett's pen froze mid-note, her face a mask of restraint, but her eyes betrayed a flicker of unease. Bondi's relentless use of Barrett's own words was like a mirror held up to the justice, forcing her to confront her own principles. The other justices, now fully engaged, peppered Bondi with questions, but she navigated them with surgical precision, always circling back to her core argument. Justice Sotomayor probed the regulation's scope, and Bondi responded with a detailed breakdown of its targeted application, reinforcing its constitutional grounding. But Barrett wasn't finished. "General, your reliance on economic impact feels like a blank check. If we follow your logic, any regulation with a dollar figure attached becomes untouchable. That's not textualism, it's activism." The accusation was a bombshell, a direct challenge to Bondi's credibility. The room gasped, and even the Chief Justice raised an eyebrow. Barrett leaned forward, her voice cutting through the silence. "Convince me this isn't a power grab disguised as constitutional fidelity." Bondi's response was immediate, her tone rising with conviction. "Justice, textualism demands we read the Constitution as it was written, not as we wish it to be. The Commerce Clause's text and history, as you've written, empower Congress to tackle economic harms that cross state lines. This regulation is no power grab. It's a response to a crisis Meridian's own data proves." She paused, her gaze locked on Barrett. "With respect, Justice, your own scholarship warns against judicial overreach that ignores textual clarity. That's the risk if we strike this down." The exchange was a high-wire act, each woman pushing the other to the brink. Spectators sat frozen, their breaths shallow, as the courtroom became a battleground of ideas. Barrett's silence after Bondi's response was deafening, her expression unreadable, but her posture rigid. Had Bondi's relentless pressure forced a crack in the justice's resolve, or was Barrett merely biding her time? The session neared its close, but the tension showed no sign of easing. As Bondi stepped back, the room erupted in whispers, every eye on Barrett. The justice's next move could tip the scales, and the legal world was watching, waiting for the fallout of this unprecedented clash. The Supreme Court chamber thrummed with tension as Pam Bondi's words echoed, her challenge to Justice Amy, Coney Barrett unanswered. Barrett's rigid silence gripped the room. Would she strike back, or had Bondi's precision broken her? The whispers in the courtroom swelled, a tide of speculation crashing against the marble walls. Every eye remained on Justice Amy Coney Barrett, whose unyielding posture betrayed the storm beneath her composed exterior. Pam Bondi, standing at the podium, radiated a quiet confidence, her gaze steady but not smug. The Attorney General had turned the oral argument into a masterclass, wielding precedent and Barrett's own scholarship like a blade. Yet the session wasn't over, and Barrett, known for her intellectual tenacity, was not one to cede ground easily. The Chief Justice's voice cut through the murmur, calling for the final round of questions, and the room snapped back to attention, bracing for the next clash. Barrett leaned forward, her eyes narrowing as she addressed Bondi. "General, you've built an impressive house of cards, but it rests on a shaky foundation. You claim this regulation is narrowly tailored, yet Meridian's counsel argues it imposes crippling costs on businesses, stifling economic liberty. How do you square that with the Fifth Amendment's protections against regulatory takings?" The question was a grenade, shifting the battle to new constitutional terrain. Barrett's tone, calm but barbed, signaled a shift from defense to offense, aiming to expose a weakness in Bondi's armor. The audience stirred, sensing the justice's intent to reclaim control. Bondi didn't flinch. "Justice Barrett, the Fifth Amendment guards against uncompensated takings, not reasonable regulations. This court's precedent in Penn Central v. New York City makes clear that regulations serving a public purpose, like workplace safety, don't constitute takings unless they destroy all economic value. Meridian's own financials show a 9% profit increase last year, hardly a taking." Her response was crisp, grounded in case law and fact, dismantling Barrett's challenge with surgical precision. She pressed further. "The public purpose here is undeniable, preventing worker deaths that disrupt families and markets alike." Barrett's pen tapped once, a telltale sign of her recalibrating. "You're glossing over the burden, General," she shot back. "Meridian's counsel cites compliance costs of $2 billion annually. That's not trivial. At what point does a regulation's cost outweigh its public benefit, especially when it treads on economic liberty?" The question was a dagger, forcing Bondi to navigate a delicate balance between constitutional principle and practical impact. The room held its breath, reporters scribbling as the exchange escalated. Even Justice Thomas, usually silent, leaned forward. His interest piqued. Bondi's voice rose, firm but measured. "Justice, economic liberty isn't a blank check to externalize costs onto workers and consumers. The $2 billion Meridian cites pales against the $5 billion in the economic losses from workplace injuries, as documented by the Bureau of Labor Statistics. This regulation balances liberty with responsibility." Then, in a bold stroke, she turned Barrett's own words against her again. "In your 2020 opinion in Barr v. American Association of Political Consultants, Justice, you wrote that constitutional protections must account for societal costs. That principle applies here." The courtroom gasped, the air crackling with the weight of Bondi's audacity. Barrett's face remained impassive, but her eyes flickered, a fleeting crack in her judicial mask. The other justices, now fully drawn into the duel, fired their own questions. Justice Kagan probed the regulation's enforcement mechanisms, and Bondi responded with a detailed breakdown, never losing sight of Barrett's challenge. The Attorney General's command of the case was unshakable, her preparation a shield against every thrust. Yet Barrett, undeterred, circled back. "General, you're asking us to defer to Congress's cost-benefit analysis. That's not our role. Textualism demands we scrutinize the Constitution's limits, not rubber-stamp federal power." Bondi met the challenge head-on. "Justice, textualism demands fidelity to the Constitution's text and purpose." The Commerce Clause and Fifth Amendment read together, "Permit regulations that address national harms without destroying property rights." This regulation does exactly that, as Meridian's own data confirms. Her words were a clarion call, echoing Barrett's own judicial philosophy while defending the government's position. The room was a pressure cooker, every spectator riveted by the intellectual joust. Barrett's silence after Bondi's response was heavy, her pen still, her gaze fixed on the Attorney General. As the Chief Justice signaled the session's close, the tension remained palpable. Bondi stepped back, her posture unshaken, while Barrett leaned back, her expression a fortress of restraint. The audience buzzed with whispers, dissecting every word, every glance. Had Bondi's relentless precision forced Barrett to question her stance, or was the justice merely gathering strength for a final blow? The oral arguments were over, but the case's fate hung in the balance, and the legal world waited, breathless, for the court's decision. The Supreme Court chamber emptied, but the echo of Pam Bondi's clash with Justice Amy Coney Barrett lingered. As the justices deliberated, the legal world buzzed, dissecting the duel. Would Barrett bend or strike back in the ruling? The courtroom, now silent, seemed to hold its breath in the days following the oral arguments of Meridian Industries versus the Department of Labor. Outside, the legal community erupted in debate, law blogs and newsrooms dissecting every moment of Pam Bondi's audacious performance. Her relentless precision, turning Justice Amy Coney Barrett's own scholarship against her, had become the talk of the nation. Social media platforms buzzed with clips of the exchange, legal scholars praising Bondi's preparation while others speculated on Barrett's unreadable silence. Had the Attorney General's barrage cracked the justice's textualist resolve, or was Barrett in the quiet of the court's conference room crafting a response to reassert her authority? In the Supreme Court's private deliberations, the atmosphere was no less charged. The justices, gathered around a mahogany table, debated the case's constitutional nuances. Barrett, known for her meticulous preparation, took the lead, her voice steady but carrying an edge that hinted at the courtroom's lingering sting. "The Commerce Clause isn't a catch-all," she argued, her eyes scanning her colleagues. "Meridian's claim of regulatory overreach deserves scrutiny. Bondi's economic data is compelling, but we can't let numbers trump constitutional limits." Her words were a rallying cry for federalism, echoing her courtroom challenges. But a few justices noticed a subtle shift, a hesitation when she referenced Bondi's citations. Justice Gorsuch, typically aligned with Barrett's originalism, pushed back. "Amy, Bondi's point about interstate impact isn't trivial. Gibbons v. Ogden and Jones and Laughlin support her reading. Are we ignoring precedent to curb federal power?" The question hung heavy, a rare moment of tension among the court's conservative wing. Barrett's jaw tightened, but she countered, "Precedent isn't a blank check. Lopez and NFIB set clear boundaries. We need to balance economic reality with textual fidelity." Yet her tone lacked its usual certainty, and Justice Kavanaugh, sensing the opening, pressed further. "Bondi quoted your own writings on congressional flexibility. How do you square that with striking this down?" The room stilled. Barrett's fingers tapped the table, a rare tell. "My writings demand fidelity to the text's original meaning," she said, but her voice softened, as if wrestling with Bondi's arguments internally. The deliberation stretched on, with Justices Sotomayor and Kagan arguing for upholding the regulation, citing its public safety benefits. The Chief Justice, ever the pragmatist, sought a middle ground, but Barrett's internal struggle was palpable. Bondi's relentless use of her own scholarship had planted a seed of doubt, forcing Barrett to confront the consistency of her judicial philosophy. Outside, the media frenzy intensified. Legal analysts on cable news debated whether Bondi had outmaneuvered Barrett, with some calling it a generational moment in advocacy. "Bondi didn't just argue, she redefined the battlefield," one pundit declared. Law students packed lecture halls, reenacting the exchange for mock courts, while Meridian stock fluctuated with every rumor about the court's leanings. Bondi, meanwhile, maintained a disciplined silence, her office issuing only a brief statement. "We trust the court to uphold the Constitution." But her team, privy to her exhaustive preparation, knew she'd left nothing to chance, anticipating every question, even Barrett's sharpest jabs. Back in the court, the justices neared a decision, but Barrett remained the fulcrum. In her chambers, she pored over Bondi's cited cases, her own articles spread across her desk. The Attorney General's words echoed, "Your own scholarship warns against judicial overreach." Barrett's commitment to textualism was unwavering, but Bondi's argument had exposed a tension. Could she dismiss the regulation without contradicting her own principles? Late into the night, she drafted her opinion, her pen hesitating over key passages. The other justices, aware of her struggle, awaited her final stance, knowing it could tip the majority. The legal world, too, waited, its pulse quickening with every passing day. Law reviews published speculative pieces and betting. Pools formed among clerks on whether Barrett would uphold or strike down the regulation. The case had transcended its legal bounds, becoming a referendum on judicial consistency and advocacy's power. Bondi's performance had set a new standard, but the ruling would determine its legacy. Would Barrett, shaken by Bondi's precision, align with her arguments, or would she double down, asserting her judicial vision? The decision loomed, and with it, a verdict that could reshape constitutional law. As the court prepared to announce its ruling, the nation held its breath. Barrett's opinion, whatever it held, would reveal the impact of Bondi's courtroom triumph. Had the Attorney General's relentless pressure reshaped the justices' thinking, or had Barrett found a way to reclaim the narrative? The answer was imminent, and the stakes, legal, personal, and philosophical, had never been higher. The Supreme Court's ruling day dawned, the nation riveted by the clash between Pam Bondi and Justice Amy Coney Barrett. As the justices took the bench, the air crackled with anticipation. Would Bondi's triumph sway Barrett, or had the justice reclaimed her ground? The courtroom filled to capacity, reporters and scholars cramming the galleries, their notebooks ready to capture history. The Meridian Industries versus Department of Labor case had become a cultural touchstone, its outcome poised to redefine constitutional boundaries. Pam Bondi sat in the front row, her face a study in calm resolve, though her team knew the sleepless nights she'd spent refining her arguments. Across the room, Justice Amy Coney Barrett took her seat, her expression impenetrable, a stark contrast to the visible tension of the oral arguments. The nation watched via live streams, from law school auditoriums to corporate boardrooms, every viewer aware that Barrett's opinion would reveal the true impact of Bondi's relentless advocacy. The Chief Justice began, his voice steady as he announced the court's decision. In a 6-3 ruling, the court upholds the Department of Labor's regulation. A gasp rippled through the room, followed by a surge of whispers. Bondi's team exchanged glances, their restraint masking elation. The Chief Justice continued, summarizing the majority opinion, which leaned heavily on the Commerce Clause's authority to regulate interstate economic impacts. But all eyes were on Barrett, who had requested to deliver her concurring opinion, a rare move that signaled its significance. Barrett rose, her presence commanding silence. "The Constitution's text and history guide this court," she began, her voice clear but weighted with introspection. "The Commerce Clause empowers Congress to address economic harms that transcend state lines, as the Department of Labor's regulation does here. The room stilled, recognizing echoes of Bondi's arguments. Barrett continued, citing Gibbons versus Ogden and Heart of Atlanta Motel, cases Bondi had wielded with precision. Textualism demands fidelity to the framer's intent, which includes flexibility for modern economic realities, a principle I have long defended. The audience leaned forward, sensing the weight of her words. Barrett paused, her gaze sweeping the room, lingering briefly on Bondi. The Attorney General's advocacy was formidable, grounding this regulation in precedent and data. Her arguments, particularly her reference to my own writings, forced a rigorous re-examination of the constitutional balance. A murmur spread. Barrett was acknowledging Bondi's impact, a stunning admission. While I remain wary of federal overreach, the evidence here supports Congress's authority. This regulation, narrowly tailored, does not violate the Fifth or 10th Amendments. The courtroom buzzed, the legal world reeling from Barrett's concurrence. She had not only sided with Bondi, but had woven the Attorney General's reasoning into her opinion, a testament to Bondi's intellectual dominance. Yet Barrett's tone carried a defiant edge, as if to assert that her principles remained intact. This court's role is to apply the Constitution, not to bend to advocacy. However skilled, she concluded, a subtle reclaiming of her authority. But the victory was Bondi's, her preparation and audacity reshaping the case's outcome. As Barrett sat, the room erupted in restrained chaos, reporters typing furiously, spectators whispering in awe. Bondi's face remained composed, but her eyes gleamed with quiet triumph. The ruling was a landmark, affirming federal power to protect workers while setting a precedent for rigorous advocacy. Legal analysts later noted that Barrett's concurrence, steeped in Bondi's citations, marked a rare moment of a justice publicly grappling with her own philosophy, spurred by an opponent's brilliance. In the days that followed, the decision dominated headlines. Bondi's courtroom coup read one, while another declared, "Barrett bends to brilliance." Law schools incorporated the case into curricula, hailing Bondi's performance as a masterclass in preparation. Meridian stock dipped briefly, but stabilized, while labor advocates celebrated the bolstered safety standards. Bondi, ever disciplined, declined interviews, letting the ruling speak for itself. Yet her team leaked stories of her exhaustive preparation, cementing her legacy as a legal titan. Barrett, meanwhile, faced scrutiny. Some conservative scholars criticized her for yielding to Bondi, but others praised her intellectual honesty, arguing that her concurrence strengthened textualism by applying it rigorously. In private, Barrett confided to a clerk that Bondi's arguments had forced her to confront her own biases, a humbling but necessary exercise. The exchange became a case study, taught in law schools as a testament to advocacy's power to challenge even the highest authority. The legal community moved on to new cases, but the Meridian ruling endured, a beacon of constitutional clarity and a reminder that preparation could shift history. Bondi's triumph was complete, not just a win for the Department of Labor, but a redefinition of what it meant to face a justice and prevail. Barrett, though shaken, emerged stronger, her concurrence a bridge between principle and pragmatism. The courtroom duel had ended, but its echoes would shape the law for generations, a story of two women who, in one electric moment, redefined justice itself.